Greetings, my name is Davina Vini, and I will be presenting my court case on Doug C. versus the Hawaii Department of Education concerning the parents' participation in IEP developments. So, first, I'm going to start off with the most basic of all requirements of the Individuals with Disabilities Education Improvement Act. The most basic requirement for the IDEA is to make sure the parent is in the meeting and the parent has some kind of role in the development of their child's IEP. So, in fact, parental participation is central in all decisions regarding a child's program and placement, and when full and equal parent participation is abridged or denied, denial of a student's right to a free, appropriate public education, FAPE, will most likely be found. So, now we'll start talking about Doug and Spencer. So, Spencer is Doug C.'s son. He was diagnosed with autism at the age of 2. So, as a result of the condition of the department determined that Spencer is eligible to receive special education services and his educational rights are protected by the IDA. So beginning in 5th grade, Spencer's IEP placed him at a private special education facility, Horizons Academy, at the expense of the Department of Education. So on December 6, 2009, Spencer's father, Doug C., requested a special education due process hearing against the state of Hawaii Department of Education because Spencer's November 9, 2009 IEP meeting was held in his absence. So let's talk about the story of this IEP meeting. So, school personnel proposed holding the IEP meeting in late October, but Doug C. was unable to attend. The school district then proposed another date, an early meeting in November, which Doug C. could not attend. Then finally, a November 9th date was set for the IEP meeting. On the morning of the IEP meeting, Doug called to try to get it rescheduled because he was feeling sick that day. So when he called to reschedule the meeting, it was too many changes to be able to accommodate all the personnel that has to be in the meeting. You know, the gen ed teacher, the counselor, the admin, like all the different roles. So they had a hard time scheduling everybody to be in the meeting. So the school, the special education advisor at the time, chose to have the meeting without Doug C. because they did offer him to sit in virtually over the phone through meeting links, but he refused because he wanted to be there in person. So the coordinator made this decision because, I kind of said it, but we're going to go over it again, made a decision because 3 earlier efforts at holding an IEP meeting was failed. School personnel were unable to rearrange their own schedules to meet on the days requested by Doug, and the annual IEP will soon be overdue. The annual review meeting, therefore, took place without Doug C. and also without a teacher or staff member from Spencer's private school. At the meeting, the IEP was reviewed, and Spencer's placement was changed from the private school to a workplace readiness program at a local high school. So not only did they continue with the IEP, they did not have all the required members, and they changed his placement. This, at the time, of course, made Doug very upset because he really was trying to be part of his son's educational process. So Doug C. then decided to go to court for due process. So at the due process hearing, Doug C. alleged that the school district's failure to ensure his participation in the IEP meeting had resulted in denial of FAPE for his son. The hearing officer disagreed, ruling that the district had afforded Doug C. the opportunity to participate and that his absence from the meeting did not constitute denial of FAPE. Doug C. filed an appeal with the U.S. Federal District Court for Hawaii. Again, I don't know if I said it, but all this happened in Hawaii. The district court upheld the ruling of the due process hearing officer, thus finding for the school district. Doug C. then filed an appeal with the U.S. Circuit Court of Appeals in the Ninth Circuit. On June 13, 2013, the Circuit Court issued a ruling in which it reversed the decision of the lower court, thus ruling in favor of Doug C. The Circuit Court also remanded the case back to the lower court to determine whether the parent was entitled to reimbursement of Spencer's costs at the private school, because when they switched Spencer from private day to the workplace readiness program in high school, Doug decided to continue with the services from private day and pocketed himself. So he paid out of his pocket for his son's education, while all these years the school district had been paying for it. So now the decision is, are we going to reimburse him or not? So in the opinion, the court noted the school district's efforts to include the parent in the IEP meeting were not sufficient. Yes, they called. Yes, they had different dates, but they didn't feel like that was enough. Additionally, the special education coordinator had denied the parents' request to reschedule the meeting because the IEP review deadline had almost expired, which would result in failing to meet the IEP review deadline and Spencer Special Education Services lapsing. So, because he was on the road to being in compliance with the IEP, that was his decision to hurry up and have the meeting without the parent. But even if it's out of compliance, meaning that the IEP is expired, it doesn't mean that the services lapse. It just means that you need to do another one. But he used that excuse to go ahead and have the meeting without the parent, along with others, and sent home the IEP for the parent to then review. So the court found that the decision was inappropriate because parental participation should have taken priority over strict adherence to any review timelines. The court stated that there is nothing in the IDA that gives school district personnel the authority to stop providing services to a student if his or her annual IEP review was overdue. Like I said, the services don't stop just because the IEP is expired. That was the special education coordinator's reason for having the meeting without the parent, but the IEP continues. Services continue until they're not found eligible anymore. The school district had also argued that Doug C's cancellations and attempts to reschedule had disrupted the school-based IEP team member schedules. Therefore, the meeting needed to be held without Doug C's presence. The Court of Appeals curtly rejected this argument, writing, the attendance of Doug C's Spencer's parent must take priority over other members' attendance. So the appropriate way is to plan around the parent and then find everybody else to fill in the gaps. The court also dismissed the department's arguments that the follow-up IEP meeting involving Doug C. resolved the potential violation of failure to include the parent in the original IEP review. Specifically, the court held that when a school district violates the IDA by developing a new IEP without the participation of the child's parent, merely including a parent in a follow-up meeting is not enough to satisfy the requirements of the law, because the IDA requires parental involvement in the creation process. So saying that as a special education teacher and you're writing IEPs, it is okay to create a draft, but nothing should be finalized without the parents' input. And the parents should be part of the review process and very active in the roles of the IEP process in their child's education. So, in order to ensure that the rights of children with disabilities and parents of such children are protected, the IDA guarantees a FAPE to children with disabilities. So this was a violation of FAPE, and it was against what the IDA has in mind for what needs to be done for their kids, for children with disabilities. Okay, so a lot of questions arose from this case. So some of the questions were, must the school hold an IEP meeting before the annual review deadline? If the meeting is not held, Do the child services lapse until a new IEP is agreed on? We kind of already answered that. These were questions that were prior to the case. If there are logistical scheduling conflicts for an IEP meeting, is priority given to the schedules of the school staff or the parent? We answered that too, the parent. Can the school cure the failure to include a parent at an IEP meeting by convening a second IEP meeting with the parent within 30 days? If a school district violates the first prong of providing FAPE, compliance with legal procedures, must a reviewing court still determine if the district violated the second prong of FAPE, whether the IEP is reasonably calculated to enable a child to receive educational benefits? And another question that rose was, if a due process hearing officer and a U.S. District Court judge make a finding that the parent's failure to participate in an IEP meeting did not deprive the child of FAPE, what is the standard of review for U.S. Court of Appeals? Does it require a de novo review of the legal conclusions or a review of the District Court's findings of fact for clear error? So, I do believe that this court case did answer a lot of those questions because a couple of them we've already answered. So we've gone through everybody's arguments, the exploration of the reasonings why the coordinator did what they did. So the question was, must the school hold an IEP meeting before the annual review deadline? If the meeting is not held, do the child services lapse until a new IEP is agreed on? The answer to this question, we have further held that delays in meeting IEP deadlines do not deny a student a FAPE, where they do not deprive a student of any educational benefits. In the Doug C., the court explained that the department cites no authority, nor could it, for the proposition that it cannot provide any services to a student whose annual review is overdue. So another question, as I stated prior to, if there are logistical scheduling conflicts for an IEP meeting, is priority given to the schedules of the school staff or the parent. So the priority is given to the parent. The attendance of the parent must take priority over other members' attendance. An agency cannot exclude a parent from the IEP meeting in order to prioritize its representative schedules. So can a school cure the failure to include the parent at an IEP meeting by convening a second IEP meeting with the parent within 30 days? No. Parental involvement after the fact is not enough because the IDA contemplates parental involvement in the creation process. So no, the school cannot come up with its own and then go back and tell the parent, this is what we're going to do, and then want the parent to agree. So if a school district violates the first prong of providing FAPE, compliance with legal procedures, must the reviewing court still determine if the district violated the second prong of FAPE, whether the IEP is reasonably calculated to enable the child to receive educational benefits? So no. The court does not need to determine whether there was a violation of the second prong, i.e. the IEP and educational benefit. Where a court identifies a procedural violation that denied a student a FAPE, the court need not address the second prong. So if you've done one wrong, that's the one they have to address. They don't have to address the others. So the last question was, if a due process hearing officer and a U.S. District Court judge make a finding that the parent's failure to participate in an IEP meeting did not deprive the child of FAPE, what is the standard review for a U.S. Court of Appeals? Does it require a de novo review of the legal conclusions or a review of the district court's findings of fact for clear error? The answer, the standard of review for findings of fact is whether there is clear error. The standard of review for legal conclusions is de novo, without deference given to the lower court. The factual finding by the due process hearing officer and the U.S. District Court judge and the child was still provided with FAPE, even though the parent did not attend the IEP meeting, was reversed. The Doug C. Court found that it was truly a question of law, which trumped the factual finding. As a matter of law, a school district is to include the parents in an IEP meeting unless they affirmatively refuse to attend. So as long as the parent is trying to make some kind of way to get into the meeting, you have to have the meeting with the parent. So my time is running up. This case was really deep. I've learned some things on how to move with my parents, with my students with disabilities and their IEPs. But as you can see, the court ruled in favor of Doug C. And now that wraps it up for me. Have a nice day. Thank you.